Everyone, I think we can go ahead and get started. Hi, everybody. Thanks for joining us, and welcome to ONC's Innovation Exchange Outreach Series. My name is Maya Upaluru, and I work in OST's Division of Science and Innovation. First, I'd like to ask everyone again to please mute your phones for the presentations. There's a lot of people on the call, so we just want to make sure that everyone can hear properly. There'll be time at the end for questions, and we'll ask that you submit those questions to either me or Jeff using WebEx's chat function, so you can send a private message to either of us, and we'll funnel the questions that way. This virtual hangout is part of a new series of innovation outreach events, which our team has created with the goal of providing an interactive forum for ONC and HHS experts to explain important federal regulations, research, and initiatives to the innovation community. Today we're joined by Joy Pritt, ONC's Chief Privacy Officer. Joy has written extensively on the HIPAA privacy rule and works closely with national consumer organizations and federal policymakers to ensure that the protection of health information and to ensure that patients can exercise their legal right to access their health data. There will also be a copy of the slides that you'll see. We'll send it out to everyone via email afterwards, so don't worry if we go through them kind of fast. Our moderator today is Jeff Platt, the co-founder of Better, which is a mobile app described as a Siri for healthcare, which acts as a symptom navigator for patients. So thanks again for joining us, and now I'll turn it over to Jeff to start the discussion.
Thanks, Maya. Good morning, everyone. We have quite a few people on the phone. It's actually great to see such good turnout, especially right after lunch there on the East Coast. So this is fantastic. So I think we're going to start, and Maya, correct me if I'm wrong, there's a few slides that we're going to start out with from Joy. Are we going to jump right into the questions?
There are actually, I think Joy and I were thinking that we will go through the slides during the Q&A session at the end. So everybody stay tuned. Yeah.
Or as part of the issues that come up. So Maya's going to have to be on her toes when I tell her to go to slide X.
That's
fantastic. That's great. Excellent. So Joy, you got quite a title as the Chief Privacy Officer for the ONC, and that covers a lot of stuff. But as we go through HIPAA today, you're an expert. We've got 100+ people on the phone, and I was wondering if you could start out by kind of addressing the thing that I hear the most when I work with startups through Rock Health or Angel Investments or just the community. I hear people either tell me the craziest reasons about why HIPAA does or doesn't apply to them. So even though you've got all this deep expertise we'll get into and kind of creative things about the law, maybe let's start with how does an entrepreneur or a startup know that HIPAA actually does apply to them, and what's the one or two paragraph way to think through that as an entrepreneur getting into health tech?
Well, that's a really great question because it really helps me explain what I do to people, which is a little different than what OCR does. The Office for Civil Rights actually is the office here that regulates HIPAA. And so what my office does is we are HIPAA Plus. When new technology comes along or there is a new model for sharing health information, our job is to look at it, assess it, and say, hey, is there a federal privacy policy that applies to this? If there is, does it look like it works with this sort of thing? And if not, to suggest some policies as to what might be a good way of addressing any privacy issues that exist. Maya, I'm going to ask you to go to, I think it's slide 2 of my deck for people.
Sure.
And explain that HIPAA is not nearly as broad as a lot of people think it is. A little background on this for people. We, in the United States, we really regulate by sector. So if you're in the financial service industry, you follow Graham, Leach, Bliley, and some of those other protections that address the financial sector. And if you're in education, you have to follow FERPA. So HIPAA is really originally designed to cover these core organizations that are part of the healthcare sector. And one of the reasons it's a little, people think that it's got some weird quirks to it is because it originated in the Health Insurance Portability and Accountability Act. So it really was part of this mechanism to standardize healthcare claims. So you'll see these odd things come up, and I'll explain them a little bit. So who's covered by HIPAA? Almost every health plan in the United States, Medicare, Medicaid, private insurers, they're all covered by HIPAA. There is one small exception, and I have yet to meet anybody who knows a single organization that has fit into that exception, so I'm not going to go into it. Also regulates healthcare clearinghouses, and these are these third parties that translate these health claims to and out of a standard format that's required by HIPAA. Again, for most of the people on the phone, clearinghouse is not used in the way that you would necessarily use it. It's a really arcane term under HIPAA. HIPAA also governs most healthcare providers, but not all of them. You can be a healthcare provider and share health information electronically and still not be covered by HIPAA privacy rule or the security rule. And why is that? It's because of that thing that I was telling about, that it was for the insurance. So you have to, for a healthcare provider to be covered by HIPAA, they have to be engaged in certain transactions. They're generally claims related in electronic form. Into that core group of covered entities, just recently HIPAA has been expanded under the high-tech rule, the part of the Economic Recovery Act that addressed health information technology, to include in many of its provisions directly business associates. And those are organizations that perform certain functions on behalf of a covered entity that involve the use or disclosure of protected health information. Mike, can you switch to the next slide, please? Who isn't covered by HIPAA? This is really interesting. In D.C., many of our dentists don't accept health claims. So most of them aren't. If your insurer doesn't accept any health insurance or doesn't process it, says pay me up front, you deal with it, they're probably not covered by HIPAA. That includes dentist boutique practices. One that's kind of surprising is you'll get all these internet health services online, like some of these mental health consultants. They only accept credit cards. They're not covered by HIPAA. Many of the people who receive protected health information from these organizations, they may not be covered by HIPAA, even as business associates, if they're not doing a function on behalf of that person. And so one that's probably most interesting to this group is that if you receive health information directly from a consumer and you're not acting on behalf of a covered entity, chances are that you're also not a covered entity. So, for example, you have these health websites where consumers fill out surveys on their own. They're not covered.
I think that, speaking for everybody probably in the audience who is new to these things, it still feels a little overwhelming, right? There's the High-Tech Act, there's the Omnibus update, HIPAA itself is quite old, and I think that there's a fear for certain startups and for certain people working that because people don't understand it as well as you explained it about why it might not apply, everyone's really afraid to say, hey, this doesn't apply to us. Google Health, when it was still around, got a ton of bad press when they said HIPAA doesn't apply to us, although under certain circumstances that might have actually been true with your definition. So as a guideline, though, for security and privacy, if someone was to walk into your office and say, hey, Joy, how do you think I could use HIPAA to be more secure or to do a better job with privacy and policies, how might you advise someone, maybe let's say off the record, who's trying to figure out about how HIPAA deals with them? Because there's a lot of good stuff in there as well.
Well, there's a lot of good stuff in HIPAA, and even if an organization isn't covered by HIPAA, if you're offering services to consumers, and especially if you're doing it on the internet or commercially in any way, chances are you may get covered by the Federal Trade Commission Act, right? Mm-hmm. And so the very, very high-level principles that are addressed in both of those are somewhat similar, and they're based on the Fair Information Practice practices. So one of those is, this is a real common sense thing, but people should really follow it, is no surprises. All right, so consumers should understand what the purpose of your using their information is, what the purpose of why you're doing it, who you're going to share the information with, how you protect it, and that's one of the things that people have issues with is like the FTC, for example.
Sure.
Is that if you say you're going to not do something and you do it, you get yourself in trouble. Or if you overpromise, you get yourself in trouble. Or if you do things that are really outside the expectation of what a consumer has in mind, if they're getting a certain app and it's supposed to do one thing, and in the background it's accessing their email account and sending marketing procedures to everybody. Even if you're covered by HIPAA, that's really going to get you in trouble. But even if you're covered by the FTC, you're still going to find yourself in hot water. So those are, that's just a very general, I think, rule of thumb is no surprises.
Yeah, I think that's a really good way to think about it. I think for entrepreneurs on the phone and for healthcare that are on the phone, when you think through a lot of these challenges, there's two important things there that you raised that we won't be able to get to in a huge amount of detail today, but there's more out there than just HIPAA, the FTC being a really good example. I mean, the first two applications that got dinged for healthcare-related claims wasn't the FDA or ONC, but was actually, or OCR, but was actually FTC with those acne apps. So doing what you say you're going to do is critically important. I think that leads to this next question, though, for new entrepreneurs or folks in the space, which is, so let's pretend that HIPAA does apply to everyone on the phone.
Okay.
And they are doing something as a business associate for a payer or someone like that. So it's a really clear case. Let's just remove any of the complexity and say, okay, I want to say that I'm done, that am I certified? Am I approved? Maybe people are used to the idea of like going through the Apple App Store and I go through a process and I'm done at the end and they've kind of given me a seal of approval. What is the analog? In the FDA world, it's the same thing with a 510K. You're not really approved, you're cleared. What is the analog for someone to know that they have done a good job, be it an audit or something else, so they can kind of inform the outside world that we comply, if you will?
Well, there is not an official mechanism, an official seal of approval under HIPAA. And I often warned people who say, well, this vendor came in and they told me, we hear this a lot in the electronic health record market. Vendor came in and they told me, here, buy my product and I'll be HIPAA compliant. For one thing, you can't be HIPAA compliant just by buying a product because, HIPAA involves having policies in place and practices, and the security piece is the technology. So you need to be a little bit careful about overpromising with that, for one thing, I think. But and the other part is, we do have an accreditation, a certification program. It is only designed for electronic health records, and it is only designed for professionals and hospitals that qualify for incentive payments for meaningfully using qualified EHRs. So it's meaningful, but it's this kind of narrow category when you think about it. So when people say that they have a qualified EHR, that has a real specific meaning. That's the only thing we have in place now, and there's nothing that says that there's no official program at HHS for certifying your practice or your technology or your service as being HIPAA compliant. Having said that, I will also say that I have heard the Office for Civil Rights make it very clear that when the category of information that will get you, of behavior that gets you in really hot water under HIPAA, and that's willful behavior. bad behavior, willful neglect or willful, behavior. The way to get yourself out of that category, and if you fall into that category, let me make it clear that you rise to a whole nother level of fines. It's like the top level. You never want to be there. But if you can show that you've made good faith efforts to comply with HIPAA, that gets you out of that category very quickly. So, in some ways of showing that are, for example, OCR put out their audit protocol, and they have that posted on the web. And if you go through that and you say, I'm going to look at all these things that an OCR auditor might look at if they came into my office, and you document that you've done that, and you do it, and you document it, that would be very helpful. Or there are a couple commercial organizations out that this sort of thing. We don't endorse anybody that does it, but if somebody comes in and does that kind of an audit for you, that would also, and you document it, that also shows that you're making a really good faith effort to do the right thing.
Yeah, I think that one of the things that I've done a lot in the past, and I've suggested to other companies, is those third-party organizations. Again, not endorsing any specific ones, but the idea to have somebody come through and take you through the audit protocol, because you raised something really, really important early in the paragraph that I want to highlight for the entrepreneurs on the phone, which is that science is not technology. In fact, I think it's like 70 or 80% if you go through the audit lines are actually process work. Are people trained? Do procedures about who has access to what data? And a lot of it is setting up, processes and controls and practices within your organization. It's not an API or not running a port scan or not just encrypting your database, especially when you get into the security, the privacy part of it. So I think those are both really important things that you highlighted that I just want to remind everyone of on the phone when they think through the process. I think there's one other thing, and let's take a second for everyone on the phone to exhale a little, because as entrepreneurs, what you're hearing from the ONC is, act in good faith, do what you say you're going to do, use the tools that are out there, be they, audit tools. There's some good NIST tools that are out there. There's a lot of good stuff to help you know whether you're in compliance and also whether this even applies to you. So I think a lot of folks in the space, HIPAA can be confusing and can freak people out. And what you're hearing is, in the way you would with your investors or your team, you act in good faith and you kind of follow the rules as they are, starting with whether they apply to you. There's not some organization who's out to get you, but actually to make sure that we're kind of doing what's right by our patients.
Jeff, I'd like to follow up on that last point a little
Please.
bit. There have been tens of, because I want to put some of the recent monetary penalty activity in some kind of context. We've heard that the fact that there have been some significant fines that have been agreed to by some organizations in the past year or so, that some people are really discouraged about entering the healthcare market. I think it's really important to put what those fines were for and how many complaints are filed into context. So there have been literally tens of thousands of complaints filed under HIPAA. I don't know what the number are now, but when you look at the number of people who have actually been subjected to a civil monetary penalty or a settlement, I think it's still under 10, definitely under 20. So you can hardly put a percentage mark on it.
Yeah, exactly. And so many of those complaints were probably situations where HIPAA didn't even really apply. That people were even the complainer didn't understand. So
well, there is some of that, but
yeah.
What's also important to know is some of those complaints were legitimate, and
Sure.
then in reaction to that, they are investigated by OCR, and the first line still is, if it looks like people are trying to do the right thing, they help them do the right thing.
Yeah, it's not a witch hunt, and I think really important for people to understand. And, the big fines get the headlines. That's the clickbait, if you will, but that's not the norm. But that also allows, especially talking about OCR and kind of the civil rights side, is, HIPAA's nearly 20 years old. I mean, this is not new. There are certainly adjustments that have been made, and kind of one of the ways that HIPAA's migrated over the years is that there's a lot recently patient rights and how HIPAA actually helps people with data access and where that data might have been siloed. So I'd like to move from kind of, as an entrepreneur, the idea that HIPAA is a stick that someone's going to hit you with or fine you or you're going to get in trouble, and kind of segue into the ways that HIPAA kind of empowers some of the community, especially with things like Blue Button and other initiatives, and kind of this mental shift for how HIPAA moves not only about insurance agency but also kind of consumers and end users and their data.
Okay, Maya, can we have slide 4? There you go. What you raise is a great issue. People have always had the right to get a copy of their. They have the right of access, which means to get to view and get a copy of their health information since HIPAA was first promulgated back in the day. When it was originally written, if you go and read these provisions that talk about a patient's right of access, you see that they clearly were written in a time when most of this was paper-based.
Yeah.
And
1996.
Well, let's see. That was when the act was in 1999. Was 1999 was when the first draft of the rule came out.
Yeah.
And we were there, right, Jeff?
Yeah.
Anyways,
I think this phone's being recorded, so I'm not going to admit to how old I am now, Joy.
Yeah, well, I'm beyond that part.
There you go.
So, but what's really been moving this right of access, I mean, because when you had the right of access in the paper world, what you would do is you'd go in and you'd ask your healthcare provider for a copy of your medical record, and they would Xerox it and hand you this stick of papers that may be 5 or 6 inches deep and would cost you, in some states, hundreds of dollars, literally. So moving to the electronic health record has just, I think, is going to revolutionize people's ability to use their own health information. Congress recognized that in high tech. There was some language in HIPAA even before the 2009 statute, high tech, that indicated that people could get their information electronically, but it wasn't really, spelled out very clearly. But high tech, it puts it right out there, that if you have your health information, it clarifies that if your information is in an electronic format, then you have a right to get it electronically. And some of the rules still read them. They're still a little paper-based, like you have 30 days to get them. I mean, it really doesn't seem like it matches an electronic system right now, but we are in this transition period where, you have one rule that covers both paper and electronic-based. In order to try to move this forward, because we all think at HHS that a patient having access to their own health information is great because it's going to really engage them in their own care. So in order to move that effort along, one of the things we have done is we've worked with the VA, which initiated this Blue Button initiative, and now ONC has taken it on to develop technology, pretty standard technology, so people can get the access to their health information electronically.
I think this is, there is a lot that's still paper-based, and for those folks on the phone that haven't read through the law, if you're not doing anything this weekend, you can find some stuff even in the most recent omnibus updates that are pretty funny, like the 30-day example that you highlighted. But we also are still dealing in an industry that, has fax machines and there's a lot on paper, and I think remarking on it as a industry transition is very astute. I think when we think about Blue Button in particular and that initiative, the idea that with HITech Act and how these things are working. We're really pushing toward access. As entrepreneurs, that's a world of opportunity for patient data and how that gets there. And it's very likely that you might be a blue button consumer, for example, and HIPAA would actually not apply to you based on the things that we talked about earlier. And there's a lot of opportunity still thinking about FTC and other privacy and security concerns, of course, to do some really groundbreaking things there. This is where innovation, where the opportunity meets innovation to really do some interesting stuff. And so I certainly, as people are coming off of this call, if you haven't checked out the ONC sites for Blue Button and that standard and some of the new stuff like Blue Button Plus, I would certainly encourage folks to do so. Okay, so I've got a couple more. I want to make sure we have time for questions and things like that, but I've got a couple more things that I wanted to throw at you. Some of them are getting a little esoteric and specific, but that's where the fun is in this massive law. So, there was a lot in the updates that have come out recently. This is this law has been around for a long time, but there was a lot that came out and a few changes with omnibus to things like patient opting in and SMS, and there was actually there's kind of a thoughtful consideration of what's going on in technology and in even consumer technology, and we let the patient have some control over those things. Could you talk about some of the recent changes to HIPAA or clarifications in the law that you think would be particularly interesting for our audience?
Well, of course, I think the biggest change under HIPAA is the extension of most of the security rule requirements and some of the privacy rule requirements directly to business associates. And the reason that's important is because it means that if you are operating on behalf of a health plan or a healthcare provider, then you need to be very aware of the fact that you are going to be expected to follow some security that you might not think of otherwise. And I say this because we've done work on mobile technology. We've looked at some of the work that's being done on health apps, and security is one of those issues that seems to not keep pace with the rest of the technology when people are working in those areas. So as a business associate, if I were working in those areas on behalf of like a health plan or healthcare providers, I'd be really aware of that because that's one area where we see a lot of lack, not keeping up to pace with the rest of the development is in the security area.
Yeah.
Some very other parts of HIPAA that are maybe interesting to this group. One of those is, I think, how information can be used for marketing or the sale of protected health information. And a little background on that is that the HIPAA defines marketing in a way that most people who do marketing would say, huh?
Yes, very true.
It's one of those areas where you would have to read it and read all the unfortunately read a lot of the guidance on it to understand what it was designed to do. But I would say overall what it's trying to do is stop some practices that a lot of advocates in particular thought were using patient data in a way that was not helpful to the patient's health, but were generating a lot of profits. So one of those is the marketing provision, which I won't go through the long history of it, but it says that what it's trying to say is if you do certain things we know that are really hinged to a patient's health care, such as sending refill reminders and some face-to-face communications with the patient about what you think that they need to do, what products they might need to buy, then you're okay. But when you're trying to communicate to a patient about other health-related products or about, gee, you look stressed, maybe you should go to Disney World or something like that. Those are marketing, and you can't do those unless you get a person's permission.
Okay.
Yeah, the marketing provision is actually a really interesting one. Again, trying to tailor it a little bit for the folks on the phone. If you're working with payers, insurance companies, folks like that, and you're a business associate, as Joy mentioned earlier, you are responsible to the same level that they are now. But in conjunction with that, there are a lot of freemium or data-based business models out there, which is, well, maybe I can use this data to generate other income. And there's really one very, very clear exception, which is medication refills in the marketing provisions. And there's a lot about the value to the patient. And so I find that to be you might look at it traditionally, how people think about marketing, and the definition is lengthy and has 3 sub-carve-outs. And I think it's doing a pretty good job of trying to make it clear that if you're providing clinical value to the patient, that's one thing. Suggesting a generic or suggesting a different drug, or like you said, go to Disney World or buy this mattress because you're not sleeping well, that's definitely a no-no. But there are clinical specific carve-outs. But I think an area where it's really easy for startups and organizations who might be thinking about premium or other business models that are using data for purposes, but as a business associate to a payer, that could really get themselves in a lot of trouble.
Yeah. Way more.
Yeah. Excellent. All right. The last thing before we kind of open it up to a little Q&A and other slides that might be pertinent is, I jokingly I was kind of calling this HIPAA trivia, but I feel like it's more kind of like, is one thing I've got one for myself, but is there one part of HIPAA that you find that every time you talk to someone, they kind of overlook it, and it's one of those good reminders for people to say, well, if it applies to you, don't forget to read this section or this piece, or even just one particular piece of line or that you think is just really good advice for people to pay attention to, and I could certainly give mine too as we work through stuff, but as a good reminder for the folks on the phone to say, here are some of the places that here's one thing that you might not get unless you really read the detail, but don't miss this one.
Well, I'm going to use this as an opportunity for a public service announcement on a topic that has come to our attention repeatedly, which is the need to do a security risk assessment under the HIPAA security rule, and it's gotten a lot of press lately, trade press for that part of the market that focuses on qualified electronic health records and incentive payments. And what was amazing about that is there was a policy in order to get your incentive payment for using electronic health records as a healthcare provider, you're required to do something you're already required to do by another law. And people were going, well, why are you doing that? They're already required to do it. It's been one of the most useful things in raising awareness that I think we could have done, because HIPAA, as you were saying, has been around for years. Yeah. And there are all these people who are going, what's a risk assessment? What are you talking about? And they should have been doing it for the last 10, 15 years or so. So what is basically, again, is one thing that I'd like to point out, which isn't in HIPAA, but which people should really remember, is compliance but doesn't mean getting rid of your common sense. And so in a security risk assessment, a lot of what's in there is what you should do just as a good business practice. You should know where your data is. You should know where you're getting it. You should know where you're storing it. To look around you physically. Are you in a floodplain? If you're storing data for somebody who's going to need to get their hands on it, and you're in a flood zone, do you have it backed up someplace that's safe? So there's a lot in that security risk assessment that would really be helpful to people. From a secure point of view, absolutely, and from a business point of view, I would do it even if it wasn't required by the rule, frankly.
Yeah, I think that's really well said. I think that one of the things that I try to stress to all the startups that I work with, and certainly my own work, is that I use the same words you use and rearrange them a little bit. I actually think there isn't much in HIPAA that isn't common sense. But let's be honest, some of it, if you're going to move fast and you only have so much funding, or there's only so many things you do, you might skip over, like a really simple document that says, here are the different roles in my company that can access PHI and who can't. Do my developers download a copy of the database to their machine before they go home at night, and is their drive encrypted? And these things that seem really simple, but even really large organizations, it was only maybe 10 years ago, maybe 8 years ago, that we had the VA contractor have the laptop stolen off the front seat of their car with all this data in it. These aren't just startup problems, but years of experience in HIPAA, that when you use the audit protocol that you mentioned earlier and a lot of the NIST tools, you can really kind of pour jet fuel, because not every startup and not every entrepreneur has somebody like Joy on staff who can help kind of guide you through this. But there are a lot of tools for that, and there are a number of good third parties. So I certainly think that it's one of those things that you can. There's a lot of people who could avoid it, and you could skip it, and it doesn't apply to you. But you're going to have to address these problems no matter what. Why not address them in a way where a lot of smart people have worked on it?
And Jeff, you mentioned a word that if you want to play trivia, one word that's usually overlooked is document. Document it. So you can do all this, you can look around and you can run through this, but you need to document it and keep it, because that will protect you if you ever get audited. It will also protect you if you ever have an employee who goes rogue on you and does really bad things. And if you have a policy in place that says you shall not do A, one, that gives you grounds for dealing with your employee, but it also gives you grounds for dealing with a regulator. You can say, that employee was totally rogue, here's our policy.
Yeah.
And it really protects you.
A really excellent point. I think if anyone on the phone or is either thinking about coming into the space or is in the space, and you've ever done anything with the FDA, like a 510K or certainly a PMA, you're going to look at the things in the standard and the documentation and think, well, of course we would do it this way. This is easy to write it down. It's going to be there. And God forbid when something goes wrong, you know how to deal with it, whether it be an auditor. The rogue employee is a great example, because stuff unfortunately does happen. But the other thing is, like, a lot of the things, even like a security and incident plan, or you talked about, floodplains. You never really think about the bad stuff till it's staring you in the face, and HIPAA helps a lot. So even if you're not required, if you're not working with a payer, if you're not insurance, if you're not a clearinghouse, there's just a lot of value in trying to use it as a tool and apply it to your company. On the pure trivia side, I was going to say that for me, the one that always seems to surprise people, but it makes total sense when you think about it, is in the list of those 18 things that kind of make up PHI, is the facial identification of picture. A lot of people they think about forms. I think an example where the law has actually thought about might be coming. We all carry around super powerful cameras in our pockets every day, and the idea of pictures is kind of an obvious one. But the fact that it's listed in there is one of the things, is I think an example of something people might not really think about. But if you're storing your pictures on a server somewhere unencrypted and they're full frontal pictures of the person's face, you can identify them. That counts. And so little things like that are just really good reminders and guidance, I think. So excellent. So let's see. I'm going to check here. I don't see any questions yet, but we also haven't asked for any. So this would be a good time if anyone on the WebEx has particular questions they would like to raise for Joy or for myself. We can take a little bit of time and take questions.
Actually, this is Maya. I have a couple questions
that
were sent to me via chat.
Great. Thanks, Maya.
Let me go through them. Sorry. One person asked if you could, well, you did discuss the marketing rules, so maybe she asked this question before you got into that discussion, but is there a link to more detail that we could send to everybody? let's do that. And does it cover marketing in general or marketing to individual clients based on results from an assessment, for example? I'd be happy to send a link with more detail to everybody following.
Oh, that question. I think I understand what that one is. Is you're using the information to market to the general world? Are you saying, I've analyzed this hospital's data, and they have the best cardiovascular unit in the world, or are you? What it is designed to do is to say, are you marketing to an individual?
The examples in the law are all individual-based, not aggregating or, creating your kind of custom messages. I just did an analysis and a write-up for somebody, so whoever that person is, if you want to send me a private message in the chat room, I could forward you kind of a summary of what I did for this other person, if it helps you through the process. I'm not a lawyer, nor will I ever be, but I certainly wouldn't mind getting you started if it's helpful to you. Typing, I guess, is sending that message. So.
I have another question here.
Great.
Somebody's asking, where does the HIPAA fine money go? So if their privacy is jeopardized, is there, I guess, some private recourse for them, or does the money go towards preventing this error from happening again in the future?
The fine, the civil monetary fines, go to the Office of Civil Rights. This was actually clarified in the high-tech rule, because before, if they assessed the fine prior to high-tech, it would just go into the general coffers of the United States. But now the money does go to the Office for Civil Rights for enforcement purposes. And the individual, I believe the Office for Civil Rights, there is a part in high-tech that plates the individual potentially getting some of the fines, but that is still under consideration as to how that would be operationalized. I don't have a right to sue under HIPAA. You have no right to sue under the HIPAA federal law.
I propose that it should go to the host of these chats, but it turns out that didn't work out.
Okay, and I have another question. So what sort of training does a company need to provide to all their employees that handle or are working with PHI data? Maybe is there a training template or something that we could send people as well as an additional resource?
Oh, yeah, there's a good one. There's a couple of really good ones. A couple of really good websites where the basic training outlines and how to identify those things. I've got to say, this is one of those places where if you spend just a little bit of time on the web with the ONC website, again, I mentioned some of the NIST tools, there is a tremendous amount of stuff out there that's written for human beings. It's not the law. It's not, it's a summary of the law. It certainly refers to the sections, but there are a lot of good training documents and templates and tools and audit materials, but there is the quality of the materials on the web is really, really good. Summarizing things, even like the medication refill exception, if you go and read that section, 99% of people can read that and kind of really understand what it means. So I definitely would, how important and how good the quality of the web materials are today, not counting any third-party materials or training templates or things like that.
So, and I would also, thank you, Jeff, that was very nice. We work very closely with OCR, and they have made a real effort at trying to put out a lot more training materials in very plain language. There are a number of videos that are available that for free. There are a number of things on YouTube that are, I would call them a lot of them are at the awareness level, which I think is a really good place to start before you really get into some of the nuts and bolts details. But some of this, you find that people they're not even aware of what it is that they need to do. And so we also have some video games that are at that level of trying to help people just see overall some of the key things that people might be able to do. training, we anticipate people may use these in their training materials as at least a first step.
Excellent. So I've got 2 questions here that Maya just sent over. Thank you very much. I'll take the second one first because it's specific and it's interesting. I think it's going to lead to a couple of good conversations between Joy and I. So you can read the questions from Justin. Windows XP is going to end of life in April 2014. I will interject here that I'm reading this off my Mac. So no more updates from Microsoft. Does this mean XP will not be HIPAA compliant?
That goes back to original question as to whether HIPAA was ever, why it would be considered HIPAA compliant to begin with.
Yeah, I think the way to think about this, Justin, is that if you're hosting, if you're using Windows XP for certain things, it's the individual services. So I'm going to give you a really specific example, but it's a bit esoteric just to point something out. You could be running MySQL on that Windows XP server and using Gazang, which does a whole bunch of at-rest encryption. And that part might be compliant, if you will, or at least consistent with those best practices and those things that are outlined there. And there may be dozens of other things that aren't. But even so, the 80% of being in compliance or in alignment with HIPAA is going to be your organizational policies. And so I don't think that XP in particular is going to make you compliant or non-compliant. It's going to be much more specific and deeper about how you implement technologies and what you use it for, and the policies and procedures that you have. I see many more people get tripped up over policies and procedures than technology. I don't feel about that, Joy.
Absolutely. I will say that there is I'm not sure if this is where this question is coming from, but I have heard people voice concerns about, in particular, the security rules requirement about data availability as you move forward. Yeah. And that's something you do have to consider, that if you're storing data in a certain medium and it becomes obsolete, you need to make sure that you are able to somehow continue to access that information. Part of that is really, it depends on what your state laws are, but I mean, just as a practical matter, you want to be able to make sure that the information remains available to you.
Yeah, good. That's a very good example. I got another one here from Paul. He says, if I'm a business associate, if I buy policies from the internet, will I be HIPAA compliant?
Buy policies.
Yeah.
Oh, at first I thought he meant an insurance policy, but no, I think I know what he's talking about.
Yeah.
Do you want that one?
I will start.
Okay.
I think, Paul, the way to think about this is a bit like if you were in college and you bought term papers. You might pass certain things, and you might get a C, maybe get a B. If you're lucky and your professor's asleep at the wheel, I think realistically, though, you're doing a disservice to your organization. And again, I say this as someone who's not part of the ONC, not part of OCR. I think that the policies, you might want to buy them and adapt them to your organization, but I actually think if you buy those, the reason the term paper analogy works is because unless you read through that whole term paper, you don't know what's on page 17. And when an auditor comes in and says, show me your policies, you don't know if page 17 of the policy you have says, and on Tuesdays we all stand on our head. And if it says that, the auditor is going to say, show me proof that on Tuesdays you stand on your head. And you're going to be looking at them saying, that's the stupidest thing I ever heard, why would I ever do that? And the auditor's going to say, I don't care, that's what it says you do here. You really want your policies and procedures to match your organization, what you do, because what you're trying to do is show good faith compliance and trying to show that you really understand it. And it will become really clear if you've kind of built up stuff that wasn't in good faith, it was kind of like just to check the box. More likely, you will make a claim in those things that you buy that you won't actually do. And so I think it's worth it. Even if you buy them, you've got to really adapt them and take them through the process. Again, there are third parties who certainly can help with this. So maybe it's a way to get started. It's a notes approach, but it's certainly not a crutch. And I think that it might be a way to get started, but that's about it.
I'd like to chime in.
Please.
My 2 cents on that is there's a little bit of what we've been really working hard on out of our office is changing the what I would call the culture around privacy and security that we've seen pretty overwhelmingly in the healthcare sector, unfortunately, which is a perception of it as being a barrier to, this is something I have to do, I don't want to do it, I'm going to check the box, and then, I'll go and do what my real business is. I think that's a real mistake because you should really be thinking of these as being protecting not only your customers, but protecting your business. If you have health information and you're storing it for other people, that's a really valuable asset, and there will be people looking for it. And you need to protect your business assets, and you need to protect your business and your clients. So I would just really encourage a more of an attitude of I would protect this. I need to move more to recognizing that this is a business and it's good for my business than it's just something I got to do. We have questions?
Yeah, I haven't seen any come through yet. I figure we could probably take 1 or 2 more if anybody wants to send over to us in the chat room. Right now I'm out of questions. This is your opportunity. It's not often you're going to get on the phone with someone like Joy.
Or if you're just on the phone and you weren't able to get into the WebEx, please feel free to just type up on the phone.
All right, last call.
So do we have, nobody's asked, but since we do have a minute or 2 left, can we just talk briefly about the FTC?
Let's do it. That would actually be a really good idea. Yes. Let's do that.
So Mike, can you put my slides back up again? And we'll go to, I think there's the last 1 or 2. Because I think it's good for people who are innovators and entrepreneurs to realize that the FTC is becoming more active in the healthcare sector because they see this as because it's taking off so fast as an area that they need to probably keep an eye on. I don't know how many of you saw this, but FTC has announced that they're going to be doing a series of roundtables in the first quarter of 2014, and those should be very interesting. And some of those do clearly involve health. So almost everybody, whether you're in the healthcare sector or not, if you engage in business in the United States, you should probably know about the Federal Trade Commission Act. The FTC is a prime regulator under that, and they have the jurisdiction to prevent unfair or deceptive acts or practices in or affecting commerce. This is a really broad jurisdiction, especially when you look at what a deceptive act is. So this is where it comes in, where we said no surprises, so that if you say you're going to do something, you really should do it. If you say you're not going to do something, you shouldn't be doing it. You should be checking your privacy practice alongside your oh, I'm having a mind blip now. But you should make sure all your documentation of your practices are aligned, because we often see that in one place on a website it'll say, on the privacy practice site it'll say we never do X, and then you go to another part of the website and it says we do X. So those are the kinds of things that can get you in trouble. They're not out to get you. A deceptive act isn't just a little minor mistake usually. It's that it's something major that would make a consumer not buy a product or use a service. It doesn't matter if you're trying to be sneaky. Again, if you're not careful and you make inaccurate representations, that can itself get you in trouble. And actual harm is not required for the FTC to bring an enforcement action against you or to investigate you. Next slide, please. And then we have unfair acts, and the FTC has these are more difficult to actually regulate because the concept is fuzzier. You don't have somebody saying something and then acting contrary to it. It's an act that's likely to cause substantial injury to consumers, and the consumer can't avoid it. So you've kind of backed the consumer somehow in a corner that if they in your product or your service that they don't even realize that something's going on. So it's not when you ask a consumer, hey, will you say yes? And they say yes, that's okay. But when you're doing something and you make it a part of your business without really offering them any option, that can get you into more trouble. So that's just a couple of the parts of the FTC that I think entrepreneurs should be aware of. There are a number of, I would say, actions, claims that the FTC has brought on with respect to people on the Internet over the years that can give some idea of the kinds of things that they look at. But they're very different from OCR and how they enforce, because OCR looks at every complaint that's filed. FTC does what I would call very high-level triage of looking for major issues and addressing those. While you're thinking of that, also think of FTC.
Yeah, I think it's really important that people think about their regulatory strategy and they understand how the FDA, FTC, OCR, and HIPAA, how they kind of all affect things. I think this, I'm gonna a little thing to kind of start to wrap stuff up, which is, we've got several, it looks to me like maybe 200 or more people on the phone in healthcare entrepreneurship. And, a couple of weeks we've seen a lot of things that are probably not so great for our space. People, whether it's security issues or FDA issues or things like that. And this is a really new field. HIPAA might be quite old, but as this field, really grows and kind of matures, we have a responsibility to our consumers, which aren't game players and internet users, but are people seeking better health through mobile and internet technologies, electronic methods. And so these guidelines are all here, and you not only owe it to yourself and to your company to do those things, but to really think about both the community that you're part of entrepreneurship and health IT, but all those end users. These things are in place to help protect them. And if it was your family or your children or your records or your privacy, you want to know that everybody else is doing these things as well. So there are going to be days, and I will completely admit that I have had those days, where you're working on a procedure or you're working on a process and you certainly wish you were working on something else. But they're there to not only protect you and your company, but the community and most important, our end users, which is really the reason we're all in healthcare to begin with. And so if you can try to keep that frame of reference that day you're working on procedure number 72, it might help make it through some of those more tiring moments in a Word document. So it's there to work in good faith, for sure.
Mm-hmm. Okay. I actually have one more question. This is from Robert. What is the State Attorney General's office's role with HIPAA compliance enforcement, if any?
Under the HITECH Act, the State Attorney General's offices have the ability to enforce HIPAA. Unlike many federal laws, this has been made very clear under statute that they have the ability to do this, and they work, if they do decide to go that route, they work very closely with OCR to coordinate. And OCR has done training with the state attorney general's offices to ensure that everybody is using a consistent interpretation.
Health insurance just approved on nutritionist.
Great, thank you. Can I just remind everybody to mute their phones really quick? Thank you.
And I've been gaining a lot of weight due to medication and physical conditions.
Okay, so if there aren't any more questions, last chance. We have about a minute. Maybe we're actually a couple minutes over, but if there are any more pressing.
That I don't know.
If not, okay, well, thank you so much, Joy, for taking the time to share your perspective with everybody, and thank you for Jeff for guiding the discussion. We really appreciate both of your time and insight. Our next Innovation Exchange Outreach event is going to be in early January, and the topic is going to focus on the Meaningful Use Certification Program and how it can create opportunities for innovation in the startup sector. And for everybody that wasn't able to dial in, I really apologize about that, but sure we are going to be posting the recording online, and we'll be emailing it to everybody as well. So thank you so much for joining us. Hope you guys have a great holiday season, and we'll see you again in January. Thank you.
Thank you. Bye-bye.
Thank you, everyone. Bye-bye.